KSA.
Very good, interesting. And now, if we move to businesses trading between Saudi Arabia and African nations, especially in sectors like fintech, logistics, or healthcare, what should they prioritize contractually?
I think when you're dealing with the contracts, because I'll also have to highlight this because we are talking about, for instance, Kingdom of Saudi Arabia and Kenya trading. When Kingdom of Saudi Arabia and Kenya are trading, most people talk about arbitration clauses, and they put it as an addendum in a contract. I would easily advise people not to put a data protection and privacy contract as an addendum. It should just be part of the contract, main part of the contract. Those clauses ought to be entrenched in the contract. There is an issue coming up with regard to law of the seat. If you talk about arbitration, there's something we always call law of the seat. And law of the seat always dictates what kind of law will apply when there's a dispute in a trade between two countries trading. So I find this interesting. Why? Because law of the seat might conflict with the data protection laws in terms of managing a breach that has occurred with data subjects. So you have to try and harmonize that along the way and know that there's something of the city between trades between countries when there's a conflict. But also we have data protection issues that come about when you're trading. Which law will apply? Say the law of where the data comes from applies when you're transferring data. But in arbitration contracts, it's always argued that the law of the seat will dictate what law will apply. So it's important that you try and harmonize that, have thus contractual clauses that indicate how these disputes will be resolved in terms of data privacy and protection, because that is our interest. So the issue is when you are contracting, the question you ask now directly, when you are contracting, specify the roles of the controllers and the processors. Be very
Both the
specific as to
controllers
what
and
they ought to
processor,
do.
both. Yes, right.
Yes. And if their co-processors or co-controllers, include them and
Right.
specify unequivocally what their role entails. Other than that, also agree on storage or localization, because when we are trading between Kingdom of Saudi Arabia and Africa, that distance, we need to know where is the storage going to occur. Are we going to have local servers? Are we going to have the servers in KSA? If they're going to be in the KSA, will we have access to the servers? What are the procedures of access to the servers? So storage localization is equally very important. The other thing is accountability in those contracts.
Yes, right.
In case of breach, where does liability lie? And now that we are moving into the AI space, we have so many issues with regard to AI liability. But for the sake of the audience, I can send them or refer them to Air Canada case in Canada in terms of liability of AI. It's a gray area we are moving into. If that AI liability issue occurs, it's still a gray area in terms of legislation. But having said that, it is important to have accountability clauses in that kind of contract when you're trading between KSA and Africa. And just to finalize on that, I think adequacy is always a matter that can never fail to occur or surface in terms of trade or cross-border data. Adequacy is explained in each and every piece of legislation, be it the POPIA, be it the DPA, be it the PDPL. And adequacy always means that the country you're sending your data to has almost equivalent laws that protect your data subjects when they get the access to their data, legally that is. The other issue that adequacy also implies, it's always human rights. It's always centered on human rights issues. What is the record of human rights in that country you're sending the data to? It's something you need to give a listen to, and the authorities are always very critical about that. What is the standard of human rights in terms of treatment of data subjects and their rights when you're transferring the data cross-border? Very important. So I think that highlights a little bit what we really need to do when we're doing contracts in terms of cross-border data transfer.
I think in absence of adequacy list under the PDPL so far, they have not issued the adequacy list of the countries. The SADAYA they have not released until now. So it becomes much more important to cover this adequacy aspect in the bilateral contracts.
Yes.
What do you think?
It is important. Yes. Ideally, even if they haven't mentioned it, I know even if they haven't mentioned it expressly in the pieces of legislation, I'm so sure if in the customary trade that they do, they always try to at least ensure that there's something. They don't haven't called it adequate, but at least they try to ensure that where we are sending our laws, like the GDPR countries, what they do. For you to get that adequacy, it goes through a very rigorous process. And most countries, let me just say Africa, no country in Africa has even gotten an adequacy decision from the GDPR. So it shows you how difficult it is and rigorous it is to get adequacy. But you can have contracts,
Yes.
bilateral contracts that allow you to do that trade, guaranteeing that protection of data subject rights.
Adequate safeguards. Yes, correct. Right.
Yes, those safeguards.
Okay,
Yes.
now from the policy angle, and also keeping in view the robust bilateral trade between Africa and Saudi Arabia, do you see these privacy frameworks influencing Africa-Saudi digital trade in the coming years?
I think there's going to be a time where a country that cannot comply in terms of data privacy and protection won't be in a position to angle itself for trade, because no country will trust you to trade with them if you are not compliant in terms of data privacy and protection. So I'm foreseeing a scenario where even the countries that didn't really feel the need to comply will be obligated to comply just for the mere reason that they earn the trust of the Kingdom of Saudi Arabia in terms of data protection and compliance. So, if you ask me what is going to happen in the future, I foresee a scenario where countries will not trade with countries that are not willing to be data protection compliance going forward. And the trust they will have in trading with you would imply that you people have data protection safeguards. For instance, cloud service localization. The other thing would be compliance models that you people share, and probably mutual recognition agreements that we just highlighted a bit just before this question.
Yes.
In terms of trade. So, as the fintech ecosystem grows, AI issues, health data, and telemedicine issues, I think that's where we're headed to. Trust will only be earned amongst traders through compliance. That would be the ticket or the keys to the castle in terms of trade. Yes.
Very good, very good. This is really a powerful vision you have presented, Mr. Timothy. Finally,
Yes.
before closing, what's your key message for businesses navigating privacy across Africa and Saudi Arabia? We have still time, so you can a little bit elaborate also.
So my advice would be that invest your resources and time in understanding the regulatory context of the trade partner you want to engage with. Try and ensure that you understand to a T what they want in terms of data subject protection and in terms of cross-border data transfer before you trade with them. How are you going to understand this? Because ideally you'd be like, okay, I don't have to go through learning their laws, but I think you'll always find experts who you can always engage in terms of understanding the context you want to deal with in terms of trade. So it is important that at least engage an expert in the area, invest your time and resources to try and understand the law. If it's PDPL, if it's POPIA, if it is the DPA, to understand what happens in that area. So I think align your contracts. Another issue would be also just to align your contracts, data governance, and staff awareness programs to reflect trust by design. Privacy by design is something that is always being taught as a rule of the thumb in data privacy and protection. So ideally, try and create privacy by design in your mechanisms, technical and organizational measures that you undertake to ensure that you are aligned with the law. Then you should also really try and, other than engaging experts and probably aligning with the privacy obligations in terms of technical and organizational measures, also just try to create these contracts, which say the mutual agreement contracts, because it's a diplomatic issue. Most people always ask why Africa cannot be United States of Africa. Because of political issues and diplomatic issues. So before you trade with another country, try and create a mutual agreement. This one involves diplomatic approaches. Sometimes the law can be there, but without a diplomatic approach to an issue, you can't get over the line, because my law is rigid, your law is rigid, and our laws are not mutual. So therefore, we've created a wedge in between. So it is important at times to involve the diplomatic approach to try and have ad hoc contracts sometimes, or ad hoc meetings that help you do a trade as you try to align over time, because compliance is a continuous process. It is not a stage. You might be complying today, but come tomorrow, you might not be in compliance. So what's the way forward? It's a daily routine of monitoring and evaluation and trying to be in compliance. So as at the time of trade with Kingdom of Saudi Arabia, you might not be fully compliant, but only a mutual agreement or contract can get you across the line, probably with the milestones and timelines as to how the compliance is going forward. Ideally, I don't think I have the magic bullet to that, but I think that piece of advice can go a long way in terms of trading. Yes.
Now we have only 5 minutes for this meeting. Quickly, just I wanted to know, because you are deeply involved here in consulting, privacy consulting, and this as a DPO also. So, in addition to staff awareness, for example, about the privacy and the compliance of these things, what you have the perception about the awareness at the leadership level? For example, the trading companies, that what are their awareness, whether they are concerned about it, whether they know about these laws, and whether they wanted to invest in these compliances at the leadership level.
I think in this space, civic education and awareness goes a long way. Most of us pass laws without the public knowing what the law entails. The public are these people we're talking about who do the trade. When the rubber meets the road, you realize nobody knows a law because civic education and awareness was not done. So what do? Have robust mechanisms for civic education and awareness.
Very good.
Have the laws in local languages or local dialects that the local people understand to help them embrace the law. Interpret the law, because we always argue under data privacy and protection that it can be a good defense for a data subject to allege that they did not understand what that consent letter meant, that privacy notice meant, because it's in English. So what do? I have to localize it in Kiswahili, a local language that this person can digest and understand. So consent is not consent if it is not understood by a data subject. So civic education and awareness, robust mechanisms, that will help.
Okay, now just for closing now, because I have only a few minutes. Mr. Timothy, you have beautifully put everything here, and thank you very much for offering such valuable insights from the African perspective. And for our viewers, we will continue this dialogue as Africa and Saudi Arabia deepens their trade and data cooperation. So we will continue this discussion more with Mr. Timothy in the future. And I invite all the viewers to be with us to see the path, how these two regions, I can say, because Saudi Arabia is the biggest country in this region, and their alignment with this African country is very important. There is a trade between them continuously increasing, so it's important to keep an eye on it. Thank you so much, Mr. Timothy.
Thank you, Anis. Thank you for your time. I'm looking forward to more on this topic.
Sure.
Thank you.
Thank you.